About those rights, the Constitution is the higher law, and it attains a form which makes possible the attribution to it of an entirely new set of validity, the validity of a statute emanating from the sovereign people. Invested with statutory form and implemented by judicial review, the higher law becomes juristically the N1 ost fruitful foe, the people, 490, 421, Bashashar, Nath, VCJF, Del, 959, Supi I SCR, 528, referred to. If the power of amendal, ent of the Constitution is coextensive with the power of the judiciary to invalidate laws, the democratic proxeno the coordinate nature of the great departments of state arc maintained. The process harmonizes with the theory of our Constitution that the three great departments of state, the legislature, the judiciary, and the exo, are coordinate and none is superior to the other. If the power of amendment does not contain any limitation, and if the power is denied by reading into the Constitution inherent limitations to extinguish the validity of all amendments on the principle of CSS sine, I features of the Constitution which are undefined and untermed, the courts will have to lay down a new Constitution. The framers of the Constitution put any limitation on the amending power because the end of a constitution is the safety, the greatness and well-being of a people. Changes in the Constitution serve these great ends and carry out the real purposes of the Constitution. Point 22, 423. The Doctrine of Consequences has no application in construing a grant of power, ronfkered by a constitution. Wombi argument that the Constitution of India could be subverted or DCSTRYCD. I'd have hortative appeal, but it is not portable by the AXPFLCNC in Arntry. The two basic postulates ID democracy are faith ID, human reason, and faith in human nature. There is no high 11 HCR faith than faith in the ecological process. BCTWCN 1951, when this court RCC, Pickenshinklery PNJLJ unlimited power of amendment till 30 Supreme Court reports 1973 Supaskel, Goleknath decision in 1967. The normal democratic process functicities provided by the Constitution. In considering a GRT of power, the wides meaning should be given to the words of the power. Il order to EFFC 281T fully. The two exceptions to this rule are: first, in order to reconnect powers CX, C lusively conferred on different legislatures, a narrower meaning cab given to one of the powers in order that both may operate as fully as possible. Second, technical terms must be given their technical meaning, even though it is narrower than the ordinary or popular meaning, the theory of consequence. Misconstrued if it is taken to mean that considerations of policy, wisdom, and social or economic policies are concluded in the theory of consequences, considering the consequences of the exercise of the power, and by so reading down the power. The very basis of parliamentary democracy is that the exercise of power is always subject to the popular will and control. The theory of implied and inherent learning actions is a repudiation of this democratic process. 24, 425, 426, Vacher Sons, Vi London Sochi. Isai of Composerors, 1913, AC 107, CP Barar Case, 1938, FCR 18, Province of Madras, v. Governor General, 72 IA 93, State of Madras, v. Gannon Dunkerley, Co. Madras, Latide, 1959, SCR 379, Attorney General for Ontario Vires, Attorney General for Dominions, 1912, AC 571, Bank of Toronto v. Lambe, 1887, 12 Ria AC, 575 Bihar Land Reforms Case on 1952 SCR, 89 Grunt Case, 1948, Cayenne 145, Rory Vellison, 1930, ACL, Demskill Howard 6, Unoy 1C111 Trail Railroad, Co. 207 US 463, Lochner v. New York 198 US 4549, LE 937 referred to. The amending provisions in the constitutions of the United States, Canada, Australia, Ireland, and Ceylon, and judicial decisions on the power of amendment in those countries do not lend support to the submissiis. Ons that a restricted meaning should be attributed to the word amendmekne, and that implied and inherent limitations should be read into the meaning and power of amendment. Pois. Royal Island v. Palmer, 253, US 35064, 1 ED 947, Hawk via Smith, 253, U.S. 221, Lesser v. Garnett. 258, U.S. 130, United States v. Sprague. 222, U.S. 716. Referred to. Initiative and Referendum Case 1919 AC 935, Switzman-Velbing, 1957. Canada, La Vie Reports, 285, Re-R v. Hess, 1949. For Dominion Law Reports, 199. Saumur v. City of Quebec and Attorney G111 Krull of Quebec, 1953. DLR 641, Chabot v. School Commissioners of Law. Morandier and Attorney General for Quebec, 1958-12. DLR 796, Hodge v. Queen, 9 Apcas 117. Re-Alberta Legislation, 1938 to DLR 81. Taylor v. Attorney General of Queensland, 23 CLR 457.